Buckle up, folks. Today we're diving straight into the strange universe of sovereign citizens, where courtroom fantasy crashes headfirst into actual law. From the very start, Cornell McCra is hung up on how his name is written in capital letters, as if that's some kind of shield against the legal system. He insists he's not the Hard Caps Corporation, which is our first clue that this hearing is about to go off the rails. This isn't strategy, it's paperwork cosplay. Judge Bryant hasn't even settled in, and we're already knee-deep in peak pseudo-legal nonsense. McCra clearly believes he's uncovered a loophole in reality itself. Spoiler, reality always wins. And things are about to get awkward fast.
Mr. McCra, I'm ready.
I don't know how this stuff works. I'm new to this.
All right, this is case number 02-561-9901. The people of the state of Michigan versus Cornell McCra. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pre-trial conference. And Mr. McCra, your name?
Cornell Michael McCreary, ill, all lowercase, not the all cap.
Things heat up fast. McCra tries to play the sympathy card, talking about how disrespected he feels, hoping to tug at the court's emotions. But Judge Bryant cuts him off instantly. "I'm not interested in your feelings, sir." That's the kind of blunt reality check you get from a judge who's seen it all. Court isn't therapy, and she's not there to pass out tissues. She's there to move the case forward. McCra thought emotion might buy him leniency, but instead he ran headfirst into the cold, unshakable wall of judicial procedure.
Today is the date set for a pretrial conference, and Mr. McCra, I understand that you are representing yourself. So how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions, with all due respect, may I speak?
I don't answer questions to counsel. I don't answer questions. That's not my role.
Well, I just wanted to say, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Hey, Mr. McCra, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates?
Tension spikes. McCra asks to speak without restraints, but Judge Bryant shuts him down with icy clarity. "Every time you go off course, you'll be restrained. This isn't a one-man show. This is court. Whether you're in a suit or a tinfoil hat, you follow the rules." She makes it clear he'll be treated like any other lawyer, any other defendant. That's the essence of equal treatment. It doesn't care about your online credentials or self-styled titles. McCra came looking to perform. Judge Bryant came to preside. And she's not about to let him turn her courtroom into a stage for off-topic nonsense.
Motion. If you would like to file a motion with the court, I can give you a motion hearing date. But otherwise, I want to know, as it relates to this pretrial conference where you've indicated that you want to represent yourself, it is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pretrial conference. As it relates to the pretrial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court.
You're going to be restrained every time you go off course. So understand every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McCra, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias.
And here it is, the Sovereign Citizen Classic, a motion to disqualify the judge. McCra drops Michigan Court Rule 2.003 like it's an Uno reverse card. But Judge Bryant doesn't flinch. She denies it instantly and, with ease, bumps the matter to the chief judge. This moment highlights the gulf between confidence and competence. McCra thinks reciting legal codes makes him a legal scholar, but quoting rules is simple. Understanding them is the real work. His play might sound impressive on Reddit, but in Judge Bryant's courtroom, it's just noise. And that noise gets cut down with surgical precision.
I'd like to have it sent to the chief judge as required by the rules.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McCrary and ask him how does he wish to proceed with the hearing for Mr. McCrary.
Yes, Your Honor.
Violation code of judicial conduct, Judge. And I haven't
been doing this for 16 years. I know what I'm supposed to do. So, Mr. McCrary, I'm addressing your request on the recusal. So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay.
Thank you.
The rule, man.
Okay, thank you, Mr. McCrary. Thank you, Mr. McCrary.
Yes, ma'am.
Your Honor.
Yes, sir.
They indicated that he would need to file a motion for recusal before you, and if you deny that, it then goes to the chief judge.
He already did. I accepted his oral motion. I denied it. So tell them it's denied. I'm not requiring him to file a written motion. The court rules don't require a written motion. He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So, Mr. McCrary, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay?
Who do I call? The clerk?
Sir, if you just, I promise you, I've been on the bench for 16 years, and I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and you will speak with the clerk. Make sure the clerk has your current contact information so that the chief judge's office can contact you with respect to your hearing on my denial of your request for recusal. Anything further with respect to this matter? Please don't unmute. Who was saying hello?
McCra came looking for validation. What he got was a lesson. With 16 years on the bench, Judge Bryant calmly dismantles his claims, reminding him she doesn't need a written motion to deny his request. The rules don't require it. That's courtroom efficiency. While he's busy playing legal charades, she keeps the process moving. This is what happens when Google University collides with real-world law. She isn't angry. She isn't even irritated. She's simply done with the theatrics. And that, more than anything, shows who truly understands the game.
Well, what else is there, Mr. McCrary?
I would like to just say this, Judge. I have nothing personal with you. It's just that
I don't take things personally. Ms. McCrary, let me say something to you. So since we're talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say this. This case is from 2002. And correct. Maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, we're going to proceed in the matter.
This is where it all comes full circle, and Judge Bryant drops the mic. The case? It dates back to 2002. That's right, it's been hanging around longer than the iPhone has existed. If McCra had accepted a public defender, It could have ended in minutes. Instead, he chose to play sovereign chess on a checkerboard. Judge Bryant even quips that if he'd watched her YouTube cases, he might have known better. But now, he's stuck in a legal maze of his own design. This is the price of believing you're smarter than the system. And if nothing else, today proves one thing.
Asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about. I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McCrary, is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right, then, so you're all set. You have a great day, and you stay safe.
This is where the train completely derails. McCra tries to twist the case into a personal grievance, pulling in race, age, and emotions. But Judge Bryant stays ice cold. This has nothing to do with you being a 50-year-old black man. She snaps him back to reality. This is about legal facts, not identity politics. No flinch. No hesitation. She closes the hearing with absolute control. The case now moves to the chief judge, but one thing is undeniable. McCra squandered a golden chance to resolve it simply.